Youth of any age may be employed at any time in any exemption in agriculture on a farm owned or operated by their parents or person standing in place of their parent. Exemptions from hazardous order prohibitions with the exemption of the parental exemption explained above. There are only a few exemptions. Hazardous occupations in agriculture, and they apply only to 14 and 15-year-olds. The circumstances where 14 and 15-year-olds may be employed in certain hazardous occupations are student learners in a bona fide vocational agricultural program, may work in Ag HD number 1 through 5 under the written agreement which provides that number 1 work is incidental to the training. 2, work shall be intermitted for short periods of time and under the direct and close supervision of the qualified experienced person. Number 3, school shall give safety instruction coordinated by the employer with the on-the-job training. And number 4, a schedule of organized and progressive work processes to be performed on the job. Also, be prepared. Job has been prepared. Number 14 and 15-year-olds who hold certificates of completion of the 4-H federal extension training programs for tractor operation and or machine operation may work in occupations listed in HDA number 1 and number 2 for which they have been trained, provided that the youth, number 1, has been instructed by his or her employer on safe and proper operation of the specific equipment to be used, and 2, the continuously and closely supervised by the employer. Were feasible or were not feasible is checked for safety by the employer at the least of mid-morning, noon, and mid-afternoon. Employers must keep copies of written agreements and certificates under these programs. Certificates of age. The federal government does not require work permits on proof of age certificates for the minor, but employed many states, however, do require them for workers of certain ages. In addition to state labor departments, school guidance counselors might know of permits and proof of age. Certificates are required in that particular state. The Department of Labor will issue age certificates in the minor employer states does not issue them. If the minor employer states does not issue them, or if the minor is requested by his or her employer to provide one. However, the vast majority of age certificates are issued by states. The purpose of this certificate is to protect the employer from prosecution for employing an underage worker. The possession of an age certificate constitutes a good faith effort to comply with minimum age requirements. Some states require permits or age certificates for young workers. In fact, most of the age certificates issued to young workers are issued by states. The fines for violation of the requirement can result in a monetary penalty for the employer. Consult your state Department of Labor for specific information on this issue. We should do all the schools while the FLSA requires payment of at least the federal minimum wage to cover non-exempt employees. A special minimum wage of 54 to 25 per hour applies to young workers under the age of 20 during their first 90 consecutive days of employment with an employer. Other programs allowing the payment of less than the full federal minimum wage then that may be applicable to young workers are full-time students. The student learner employed pursuant to sub minimum wage certificate. Please note that these programs are not limited to the employment of workers under 14 of age. Youth Minimum Wage Program. A minimum wage of not less than 54. No, it says less than 425. But I'm going to say 54.25 so we can bring it up. May be paid to employees under the age of 20 for their first 90 days of employment with any employer as long as their work does not displace other workers after 90 days of employment or when the worker reaches the age of 20, however comes first, the worker must receive at least the federal minimum wage. Full-time student program, the program of full-time students employed in retail and service stores, agriculture, or colleges and universities. The employer that hires students can obtain the certificate from the Department of Labor, which allows the student to be paid not less than 25% of the minimum wage, or 85%. The certificate limits the hour that the students may work in 9 hours or 8 hours in a day and no more than 20 hours a week. When school is in season and 40 hours when school is out, and requires the employer to follow all child labor laws. When students graduate or leave school for good, they must be paid at least the federal minimum wage. Students Learn Program. The program is for high school students at least 15 years old who are enrolled in vocational education shop courses. An employer that hires a student can obtain a certificate from the Department of Labor, which allows the student to get paid not less than 75% of the federal minimum wage for for as long as the student is enrolled in the vocational education program. Enforcement of Labor's DOL encourages and in fact relies on employees to vocationally comply with the FLSA, including the child labor rules. However, the FLSA does provide several enforcement tools. The DOL uses these tools when necessary to compel compliance with the FLSA and to child and its child labor regulations. The FLSA gives the DOL the authority to investigate possible violations of its rules, including the power to examine an employer's records and to interview employees to determine if the employee is in compliance with the act when violations are found. The investigator will explain all the violations to the employer and seek agreements for future compliance, but the DOL also may take any of the following actions: access civil money penalties, seek an injunction in the federal courts, um, in, into, in, initiate criminal action on the federal courts. Take a hot goods action in the federal courts. Employers may be subject to a civil money penalty up to $11,000 for each employee who is the subject of a child labor violation. In addition, the FLSA permits an assessment of up to $50,000 for each violation that causes the death or serious injury of a minor. And such assessments may be doubled up to $100,000 when the violations are determined to be willful or repeated. If the penalty is assessed, the employer has the right to, within 15 days, to file an exemption in writing with the wage and hour division official who issued the assessment. When an exemption is filed, the matter is referred to for a hearing before an administrative law judge. Injunction of the federal courts, section 17 of the ELSA authorities U.S. districts courts to stop violations of the FLSA's of the requirements such as the employment of children in violation of the hazardous occupations orders or payment of through the courts can require employees to comply with the child labor regulations. Criminal action on the federal courts in the case of willful violation of the child labor rules, and FLSA provides for the time up to $10,000 offense committed after the conviction for a prior offense. A person can also be imprisoned for not more than 6 months. I say 50 years. Okay, hot goods action of the federal court, section 12. The FLSA provides that no producer, manufacturer, or dealer that shall ship or deliver for shipment, encumbrance, any goods produced in an establishment in the U.S. in or about with oppressive child was employed within 30 days prior to the removal of the goods. The provision is in addition to section 12A, which prohibits employment or oppressive child labor in the production of goods for commerce. Oppressive child labor occurs when the child labor rules are violated. Under these provisions, legal action could be taken to prevent an employer from shipping his or her product. If a child labor violations have occurred within the past 30 days, records as a defense, employers may protect themselves from violation of the age-related child labor rules by keeping on file a state-issued employment or age certificate for each youth employed to show that he or she meets minimum age requirements. Most certificate issued under state laws are applicable. The federal government no longer issues such certificates. So the policy addressing child labor, two following simple policy statement can be utilized as a starting point for an employer to easily customize as part of their employee manual for their company, and policy can be customized by adding information specific to the company. Suggestions and examples are included to give additional information and help determine these policies. The company, including the subsidizing companies, the company, I will comply with relevant and applicable state and federal labor regulations, treaties, conventions, and principles relating to the protection, welfare, and health and safety of children. Furthermore, the company will not employ any person detained by the state or federal laws, conventions, or regulations to be a child in any capacity in any industrial operation under its control. As a good corporate citizen and company is committed to the principles in protecting children from child labor, exploitation, and the company believes that their future development and that of the communities and countries in which they live is best served through education, not child labor. This is the commitment to company seeks to apply throughout the supply chain, from production to the distribution of sale manufactured, as well as the recovery of disposal waste and materials. The company acknowledges that they sometimes customize in some industries for children to play a part in the day-to-day work, partially to learn essential craft skills, ensuring the long-term sustainability of an industry. Nevertheless, the company aims to apply the commitment and principles to contracted supplies by the education through its field extension service, seeking to ensure that I want to add the book of books that Agency New Americas Now. And right here it says the welfare, the health, and safety children are paramount at all times, and I'm not with paramount. Be any form of labor undertaken by children for the development of craft skills does not conflict with the impedable their proper education development, including school attendance. No work activity that could be considered to put children at risk or is undertaken by children. Handling mechanical equipment and chemicals. So I would like to do more stuff with this. This is a good policy, and we should definitely focus on this now. So I think everybody that's 15 and 14 should just apply for that with the parents' consent and see if they do get paid and see if the education could pay that. I think that'll be a good start.